Mně nezbývá, nežli předat slovo prvnímu panelistovi a jsem ráda, že přišel mezi nás a že vlastně nám poví své praktické zkušenosti. Prosím, dámy a pánové, Christian Davis, Open Society Justice Initiative.
Good afternoon, and thank you, everyone. Take this off so I don't hear myself being translated. My name is Christian DeVos, and I'm an advocacy officer with the Open Society Justice Initiative. I'm based in our London office, and I'm delighted to be here in Prague today, and delighted to be here especially with colleagues from OSF Prague, with whom we work closely. For those who may be unfamiliar with the Justice Initiative, we're a global human rights law center that's housed within the Open Society Foundations, which, as many of you know, is a large philanthropic organization with offices around the world. The Justice Initiative engages in litigation and legal advocacy around the world, including notably before the European Court of Human Rights and the Council of Europe. And the Foundations has a deep history in Europe, as I'm sure many of you know, and a long history of activity in the Czech Republic, including the Justice Initiative's work on the landmark case that brings many of us here today, which is the infamous DH case. I've been asked to speak about equal opportunities in education from a European perspective, and I think certainly the DH judgment is central to that discussion. The decision, most of us know, was decided in 2007 by the court, and it held that the disproportionate placement of Romani children in what were then called special schools, where they, along with children with disabilities, are segregated from their mainstream peers and taught to a limited curriculum, that constituted unlawful discrimination under the European Convention of Human Rights. And I will tell you there's really no question of the significance of this judgment, I think, from the perspective of Strasbourg. I was just there yesterday, in fact. I flew in last night, and there's a new community center that has been built next to the court, and we had an event there, and they have a wall of the most notable decisions that the court has issued in its 50-year history, and amongst them is the DH case. So I was pleased to see that for many reasons. But here we are, now 8 years later, and it is evident that much remains to be done. And I say that even in spite of some of the encouraging developments that we've seen recently that the ambassador and Robert mentioned at the outset. But I would say that the decision remains substantially unimplemented, despite the fact that the court's decision and the Czech government is obliged to comply with its ruling. So I want to say a few words about what is being done at the international level before the Committee of Ministers in Strasbourg and the European Commission in Brussels to ensure that pressure continues to be brought to bear. And I'm going to just say a few words to clarify the distinction between these two bodies. I don't want to belabor the point, but I myself find it confusing sometimes, and so I just wanted to be clear that the Committee of Ministers is a political body that is based in Strasbourg, and it's comprised of all 47 member states of the Council of Europe. Its charge is to supervise the execution of all judgments of the European Court, including DH. And that committee meets regularly in Strasbourg to review the status of execution and to instruct states on what they need to do to comply with their obligations under the Convention and under the terms of the judgment. The European Commission, meanwhile, has its home in Brussels, and it is responsible for ensuring that the law of the European Union, not the Council of Europe, the European Union, of which the Czech government is also a member, is correctly applied in each member state. So where a state fails to comply with EU law, the Commission has powers to bring this infringement to an end, including, if necessary, by referring the case to the European Court of Justice, which is separate than the European Court of Human Rights. So with that clear, the two separate entities, they're two separate entities, but, and they draw their authority from two different treaties and two different bodies of law, but the Czech government is bound by both. So in this sense, they're really complementary. And I'll return to that at the end of my remarks. But first, turning to the Committee of Ministers. The Justice Initiative has been particularly involved in helping to ensure that the committee receives regular ongoing information from national partners here in the Czech Republic about what steps the government is taking or failing to take to implement the decision. And we do this by submitting regular written materials, all of which are publicly available online on the committee's website. And you can go there and see copies of every submission made by the Justice Initiative, made by CHOSIV, made by OSF Prague, made by Amnesty International, the European Roma Rights Center. I think there might even be a copy in the back of the room. And I would mention Ms. Shabatova's office has also made very important submissions to the committee as well, which I can tell you firsthand have been of great value to the committee members. And more recently, the Justice Initiative has pioneered an initiative to bring people to Strasbourg to brief committee members directly in advance of their quarterly meetings. And the DH case has now been part of these briefings on 3 occasions, and we have brought representatives from the Office of the Public Defender of Rights on 2 occasions, from the Czech Society for Inclusive Education, from OSF Prague. Jiří Nantel, the former Deputy Minister of Education, has spoken, and I'm very delighted to say that Vladimir Foist, tireless principal of an inclusive school who's here today, was just most recently with us in March of this year. And also, I will add that Niels Mužnieks, who is the Council of Europe's Commissioner for Human Rights, participated personally in one of these briefings as well. So there's a great deal of attention and interest and support in the implementation of this judgment. The committee has issued no less than 10 decisions now in the course of monitoring the DH judgment. And frankly, I was reviewing them last night. They have been quite critical of the slow rate of progress. I'm reading from the June 2014 decision of the committee, which stated that, quote, progress is slow and the results on the ground are yet to be observed. And also that, quote, the situation on the ground remains very worrying. More recently, in the March 2015 decision, the committee noted that despite recent welcome legislative amendments abolishing the possibility of short-term placement of socially disadvantaged pupils in groups or classes for children with mild mental disability, I'm quoting, that this seemed to be benefiting mostly non-Roma pupils who are transferred to mainstream education at a much higher rate than Roma pupils. So in fact, the committee noted that the share of Roma pupils being taught to the reduced curriculum remains disproportionate, and in fact, as a result of the transfer of non-Roma, has increased overall. This also raised doubts for the committee about the effectiveness of the revised diagnostic tools that the government has put in place. I say that to just underscore how seriously the committee takes the DH case and how closely it monitors the Czech government's actions. It is still waiting to see a far more substantial shift in the number of students entering or being transferred to mainstream education, and to see that the necessary support is provided to them. So in this respect, I think the important recent amendments to the Education Act have been welcomed, but the committee has also set important benchmarks that the government has to meet in order to demonstrate its commitment to implementing those amendments in practice. And at the most recent decision, the committee has asked the government to submit by September 1st of this year, to submit to it detailed information on the strategy that it envisages to implement the new legislative framework. And by February 2016, it will ask again for the most recent statistics from the Czech School Inspectorate. And I want to stress, speaking as a civil society person, that the government was, quote, strongly encouraged to enhance their cooperation with civil society, and which in our view could be far more robust, open, and collaborative than it has been so far. I'm going to turn now to the other part. In addition to this ongoing supervision, the European Commission instituted in September 2014 infringement proceedings against the Czech Republic. And in so doing, it called into question the government's compliance with the Race Equality Directive, which was commonly known as the RED. It requires EU member states to combat discrimination on the grounds of racial or ethnic origin, and it lays down minimum requirements for all EU states, implementing the principle of equal treatment between persons in the Union. It forbids direct or indirect discrimination based on race or ethnic origin. And the directive applies to all persons in both the public and private sectors. So that includes access to social protection, health care, housing, and, as is the case here, education. And the deadline for the promulgation of this directive into the national laws of EU member states, basically for EU member states to comply, was May of 2004. So 10 years later, in 2014, the Commission announced its decision to launch these infringement proceedings against the Czech Republic. And that means that the Commission considers there's sufficient evidence that there has been a breach of those articles in the red that prohibit discrimination and access to education on the grounds of race or ethnicity, and that legal enforcement action might be necessary to remedy it. So this is not formally a litigation stage, it's a pre-litigation stage, but it's a serious one. I should say, we know that the Commission has launched its proceedings. It makes a little announcement on its website, and word travels fast, but the process itself is still confidential. We understand, however, that the government has now replied to the Commission's initial letter of notice, and at this point, based on this, the Commission will choose to issue what they call a reasoned opinion, which is effectively a final written warning to the Czech government. And such an opinion would set out the reasons why the Commission considers there to have been an infringement of EU law, and then in the event that the member state fails to swiftly comply within a specified period of time, the Commission may then choose to bring the case before the European Court of Justice, or to refer the case. And to my knowledge, the Czech Republic would be the first EU country to be so referred. So, despite the confidentiality of the process, we can easily imagine that the grounds on which the Czech Republic is allegedly in violation of the red are likely to be related to the same issues that impede the effective implementation of the judgment in DH. And that includes, but not limited to, the need to address ongoing problems with the legal framework of the Czech educational system. And I highlight here the failure to yet repeal and revise the framework education program for children with mild mental disorders, the need for budgetary increases to ensure that the amendments to the Education Act are actually put into place, continued improvements to the diagnostic tools that the government is using, and far better methods for evaluating and tracking data on the numbers and the ethnicity of children that are being educated on a limited curriculum. So 7 years later, the government's actions in relation to the DH judgment still are under enhanced supervision of the Committee of Ministers. This is quite significant. A small percentage of cases remain under the Committee of Ministers' enhanced supervision. And the structural separation of Roma children in education is continuing. The European community, I think, has clearly said this is unacceptable in one voice. And in this sense, the failure to adequately and swiftly implement the DH judgment has contributed to these infringement proceedings that we're now talking about. In effect, they're another enforcement mechanism, and they're quite linked in that respect. And as the Committee of Ministers continues to await results that show a genuine change in the treatment of Romani children in particular, and in the government's broader approach to inclusive education, I would just close by saying we as civil society certainly remain committed to ensuring that the committee receives credible, independent information from people directly affected by and engaged in this ongoing struggle. I'll stop there.